From 2014 to the present date, Maura Healey has been on a rampage to ensure that Jason Davis never obtained justice. She picked up the baton of corruption from an assortment of power brokers involved in this case, and there are a lot of them. Maura Healey has been an abuser and a bully to Jason Davis since 2014. He is voiceless. He is powerless. She pretends that she's a great friend of the mentally ill. She has done everything within her power to make sure that Jason Davis never gets justice. Everything in her power.
Hey, everybody. Welcome back to the Mike Urban Show. I'm here with Chris Perry. He is an attorney that has been diligently working on a case for a very, very long time today. And we're going to go over that case, and what we're going to do is pretty much expose some of the back-end stuff, kind of pull the curtain away of what's happening in Massachusetts. Chris?
Thank you very much. I appreciate being here today, and I appreciate being able to tell Jason Davis' story.
Listen, it's a pleasure for you to be here, and I think that this story deserves to be heard, and it deserves to be seen as well. Because what has happened, your dad was working on this case as well, correct?
That's correct.
And then you've sort of picked up the torch, right? And
yes,
you've been running with this case. If you don't mind, do you mind bringing people, I did a video on this, but if you want to bring people up to speed on what happened from the beginning, I think that would be a good start.
I'd be glad to. And again, my name is Christopher Perry. I'm an attorney in Holliston, Massachusetts. And in the 1996 time frame, approximately March of 1996, Jason Davis came into my office, and a friend of his drove him to my office. Mm-hmm. He came in that day, and he talked about his case. And basically what happened to Jason Davis, on August 12, 1993, Jason Davis was a committed mentally ill patient at the Westboro State Hospital. On that day, he was savagely brutalized by 6 or 7 mental health care workers. A number of these mental health care workers pinned him to the floor in the ward. One of the main culprits here was Philip Bragg. Philip Bragg was a convicted violent felon on the date of the incident. He had spent some time in jail for shooting a boy in the eye with the gun at short range, so he was up on attempted murder charges. There was another convicted felon as well, Paul Rennie. He had been convicted twice for armed robbery, once with the gun, once with the metal pipe. So they ganged upon him on August 12. They beat him bloody. Philip Bragg actually tried to murder Jason Davis on that date by snapping his neck in two. Luckily, a state police officer was on the scene. Mm-hmm. He intervened. He stopped the attack. There was blood all over the place, all over the ward, all over Jason's face. He was bleeding from his gums, his mouth, his eyes, his nose. He was choking on his own blood. Blood all over his shirt, his pants, the floor. There were literally puddles of blood on the floor. And I say this case went all the way to the U.S. Supreme Court. Everything I talk about here today is gospel fact. It's been proven. We had a 1-month trial. The Commonwealth, through the Attorney General's office, took an appeal to the First Circuit Court of Appeals. They lost there. Then they took an appeal to the U.S. Supreme Court. It was an horrific scene. After they beat him bloody and tried to murder him by snapping his neck in two, literally, as the police officer, the state police officer testified, they then strapped him to a restraint table, face down, where they strapped him for an hour, blood coming out of his nose, choking on his blood, unable to breathe. It was a pathetic circumstance. Finally, the federal federal human rights officer, Kermit Brown, came down, immediately ordered him unstrapped. He went into the bathroom. He threw up for half an hour or so, throwing up his own blood. Mm-hmm. So after all of this, he was transported to the hospital. Then the cover-up started in. The charge nurse on the scene doctored the records, made false allegations against a hero state police officer. It was incredible. Remember one record she doctored up. Unknown precipitants to the injury. Unknown source of his injuries. She was elbow to elbow with the state police officer as he's intervening, screaming at her to stop the assault. Interestingly, Philip Bragg, the main culprit here, who put his knee on Jason Davis's head and tried to snap his neck in two, to literally kill him, they were boyfriend and girlfriend. the charge nurse and Philip Bragg.
Really?
Boyfriend and girlfriend, that came out at trial. It was interesting at trial. Joyce Wiegand said wasn't true. Phil Bragg said it was true and that he came home and talked to her about the incident all the time. So after that occurred, Jason Davis was so terrified that he didn't get a lawyer for 3 years. Finally, he tried to get a lawyer nearly 3 years out. And he was mindful it was a 3-year statute of limitations. He came into my office in March, as I said, of 1996. My father was out that day, and he was terrified to even talk about it. And I asked him that day, I said, Jason, you know, you got plenty of time. We're good. But how come you waited so long? He says, I was afraid.
Yeah.
He says, I was afraid that they'd do it to me all over again, and I have to go into these institutions. So finally, we started suit, August 2, 1996. And basically, just to go back here for a second, I just want to make one thing real clear. Governor Maura Healey set upon the Davis family and vindictively targeted them to make sure that they would never obtain justice. From 2014 to the present date, Maura Healey has been on a rampage to ensure that Jason Davis never obtained justice. She picked up the baton of corruption from an assortment of power brokers involved in this case, and there are a lot of them. Scott Harshbarger, Thomas Riley, Maura Healey as assistant AG, Maura Healey as AG, Maura Healey as governor, Martha Coakley as AG, Governor Deval Patrick. The list goes on and on. Karen Spilker engaged in conduct here. All these individuals I just talked about, all of them engaged in corruption relative to the Jason Davis case. So Maura Healey picked up the baton and charged forward. I thought it was interesting, though, this summer, quite frankly, where Maura Healey spoke at the Democratic National Convention. And she had this to say, and when I heard it, it made my jaw drop. And she said this. August 24, again, on the floor of the Democratic National Convention. We should stand up for abusers and bullies, and we should stand up for the voiceless and the vulnerable. I want to be real clear about one thing. Maura Healey has been an abuser and a bully to Jason Davis since 2014. He is voiceless. He is powerless. She pretends that she's a great friend of the mentally ill. She has done everything within her power to make sure that Jason Davis never gets justice. Everything in her power. This is kind of odd, though, because the Democrats in Massachusetts, the politicians in Massachusetts, they make all the great comments about this case. And we have an assortment of quotes. A quote from, for instance, Senator Markey said this on August 29, 2020 to the Boston Herald. Jason Davis deserves justice, and his family is owed their full settlement. Elizabeth Warren, same date, same article. Jason Davis and his family deserve justice, including the full settlement that they're owed. Maura Healey. I talked to Maura Healey about this case on May 10, 2014, when she was running for Attorney General. She was in the Holliston Gymnasium at the time. She said that the Jason Davis case was a very sad situation. Karen Spilker, quote, email to me. Clearly, these issues, both mental health and the Davis matter, are very, very important to me. Goes on and on and on. What I do know, though, is the Davis family asked Maura Healey for help 8 different times in writing. Each time, she said no. Absolutely refused to help Jason Davis. I thought it would be appropriate today. I'm going to talk about corruption here a little bit. I thought it would be appropriate for me today, though. This term gets bandied about in the press a lot. People use the term, but I don't think people understand precisely what it means. I think it's important to note what corruption means. And I have two definitions of corruption from Black's Law Dictionary, 9th edition. Number 1, here's the first one, and I quote, the act of an official or fiduciary person who unlawfully or wrongfully uses his station or character to procure some benefits for himself or another person, contrary to the duty or the rights of others. So, violating the law is corruption. Violating the rights of another person in the law is corruption. The second definition, quote, spoiled, tainted, vitiated, depraved, debased, morally degenerate, as used as a verb to change one's morals and principles from good to bad. So, for the purposes of our discussion here today, depriving somebody of their rights is corruption. Not complying with the duty that you owe as a public official, corruption. So failure to comply with your own duty, depriving a person of rights, or engaging in morally depraved conduct. Once we get through today, it'll be perfectly obvious to everybody who hears this video that Maura Healey and Andrea J. Campbell have engaged in acute corruption around the indemnification program that they have in the state of Massachusetts. This conduct is criminal. It violates 18 U.S.C. Section 242, which is basically just the criminal cousin of the Federal Civil Rights Act. It violates the Equal Protection and Due Process Clause as well. They're both corrupt. They both engaged in corruption relative to the Jason Davis case. There are an assortment of other individuals as well. Thomas Riley, Scott Harshbarger, Martha Coakley, Maura Healey with 3 hats on, Deval Patrick, all of them engaged in acute corruption. As you so correctly pointed out in your first video on this case, I mean, you hit the nail on the head. You said they can't help Jason Davis because to do so would be to shine a light on what happened here. So we engage in a 1-month trial. You know, interestingly, the trial started on September 29, 1998, went for 1 month. It's a 4-week trial. But we didn't start suit until August 2, 1996. I filed the complaint myself. The incident occurred in 93, so it was almost 3 years post-incident. So Scott Harshbarger was the first person who stuck his toe in the water, immediately comes in, but he had 3 years to look at all the records. The state police officer who intervened, he generated 3 or 4 arrest reports. The DMH did an investigation. All the witnesses were interviewed. The Disabled Persons Protection Commission did an investigation. There was a whole plethora of documents available, so he could have found out. All he had to do was talk to the state police officer, talk to Jason Davis, talk to the civil rights officer. That's all he had to do to find out the real skinny. But what did he do? He came in immediately and circled the wagons. Deflect blame. He came in immediately and defended the attackers of Jason Davis, all those people who pinned him to the floor so that Philip Bragg could try to murder him. Now, there was something terribly wrong with that. It was corruption. The United States Supreme Court said 11 years before the incident, you must protect the committed mentally ill. They can't be subject to violence at the hands of state employees employed in a mental hospital. So what happened here? Harshbarger comes in, defends all the attackers. You can't protect the mentally ill against violence if you defend the attackers who engaged in the very violence that you need to protect the patient from. It was corruption, A+ corruption by Harshbarger. He came in, he did this, it was against the law, it was corrupt. What he should have done is he should have indicted all of these people. These people could have been indicted under 18 U.S.C. Section 242 federally, and they could have been indicted, obviously, under state charges as well. So he didn't use that 3-year period too well. He came in immediately and defended these criminals when he should have indicted them. What else did he do? He engaged in some representation of these people that was absolutely incredible. The common issue that he put forth, they all put forth. The Attorney General was in this case from the get-go. Federal District Court 1-month trial, appeal at the First Circuit, U.S. Supreme Court. The issue that was their prime issue, it's okay for mental health care workers to stand idly by when one of their fellow employees is brutalizing a mentally ill inpatient. So what he was trying to do is to get his clients off, the people who pinned Jason Davis to the floor so that Philip Bragg could try to murder him by snapping his neck. Those are the people that he was saying they have no obligation to intervene. Even if they have the time, the opportunity, and ability to intervene, they have no obligation to intervene. You know, it's kind of interesting with an attorney general. They cannot espouse a position in any court that is not good for the entire populace. For instance, if they take a position that might be good for their clients, but it's bad for the whole class of mentally ill people, then they cannot do that in a court. That's what he did here. If that position had been adopted by the 3 courts that rejected it, it would have resulted in a license to maim, injure, and kill the mentally ill. This is what he was trying to do. Judge Lasker was sitting in the Federal District Court. Judge Lasker is a Hall of Fame judge, 25 years at the Southern District of New York. He was a legend in the Southern District. Some people say that he was U.S. Supreme Court timber, and he was. And he was in the most important federal district court in the country, and he was the prime go-to guy in that district. He rejected this contention out of hand. The First Circuit rejected it. That's the First Circuit Court of Appeals in Boston. They rejected it out of hand. The Supreme Court rejected it when they denied the petition for certiorari. But Scott Harshbarger didn't stop there. He had another issue in his quiver, and this issue was, there's a nuance in the Due Process Clause that basically says you cannot have rights under the Due Process Clause if you're in a mental institution, if you're there voluntarily. So if you check yourself in, you or I, today we go, we're competent, we check ourselves in, we have no due process rights. I don't like that ruling, but that's the law and we comply with it. Now, Jason Davis checked himself in, but at the time he checked himself in, he was totally incompetent. He was delusional. He was hallucinogenic. He was having auditory hallucinations, visual hallucinations, suffering from acute incompetency, acute depression. And I got the depositions of the doctor who checked him out of McLean on May 13, 1998, and the doctor who checked him into the Westboro State Hospital. Both of those doctors said he was not in a position where he could execute a voluntary admission form. He was totally incompetent.
Right.
What did Harshbarger do? Harshbarger says, I want to dismiss the whole case, and he files a motion to dismiss it. I had the depositions from the 2 doctors. I had all this other information. Thing went nowhere. Judge Lasker shredded him. There's a reported opinion, and for your legal beagles out there, the reported opinion is Davis v. Rennie, 997 F. Sup. 137. Judge Lasker said there's not a shred of facts or evidence that you could use to support your position. Your position is totally baseless. Why did he do it? He did it because he wanted to beat Jason Davis and get rid of the case. But again, these 2 issues would have been horrible for the mental health community, because you could look away and see your friend at the mental institution brutalizing somebody, and you would check your constitutional rights at the door if you could be compelled to sign, quote unquote, sign a voluntary at the front door. So it gets rid of all the constitutional rights. You have no constitutional rights. Would have been horrific. He didn't care about that, though. He didn't care about that. So, it's kind of interesting. We had mediation, too, with Scott Harshbarger. Mediation was more corruption. Once again, Scott Harshbarger had a duty to protect the mentally ill. These 2 legal positions of his were totally corrupt, as we've heard in terms of the definition.
Yeah.
Jason Davis had a duty to be free from violence. Harshbarger had an obligation to protect Jason Davis. So these 2 issues, corruption, per se corruption. So then we get into mediation, and we went to mediation. It was Jason, my dad, and myself. My dad was a lawyer on this case for a long time, and mediation took place in May of 1998. He had been a lawyer at that point in time for 38 years. He came in 1960 as a lawyer. And I know I'm biased, but my dad was a great lawyer. So the 3 of us attend mediation. We're in front of Senior District Judge Mazzoni, who did the Boston Harbor cleanup. Great judge in his own right. We get into mediation. Scott Harshbarger, they got a whole team there, 7 or 8 lawyers from the AG's office. And their proposal to Jason Davis was, we give you $500,000, Jason, but you're not going to see a nickel of it. Your lawyers are going to get a third. You're not going to see a nickel, and anything that you would have gotten is going to come back to us as back rent. The fly in the ointment with that, even talking about that proposal, was the most unethical settlement offer I have ever heard in my life, and my father the same. We went out, we talked to Jason in the hallway, abutting the mediation. It was incredible. His dad has given me permission to talk about what Jason said, because it's still subject to attorney-client privilege. So Get out in the hallway, his face is clammy, he's sweating a little bit, it's white, and he says, no, it's happening all over again. They're doing it to me again. I said, don't worry, Jason. My dad said, and he said, Chris, Mr. Perry, don't let it happen. We said, don't worry, Jason. We would never take that offer. It's totally unethical. It's immoral. It's illegal. It's criminal. We could get disbarred. We don't even want to talk about that with them. So we get back into the mediation with Judge Mazzoni, and my father just goes ballistic. And he runs up one side and down the other side of Hochberger's team. In all his years, he never heard of it. And I said the same thing. Finally, Judge Mazzoni slams his hand on the table and he says, Jason Davis has the lawyers, he has the case, and he's going to ring the bell at trial. And we did. And we did. The jury verdict came back at $1.65 million, and Judge Laska, the venerable senior district judge, Morrissey Laska, added another $500,000 in attorney's fees. So, it's just a terrible situation.
It's unbelievable.
It's a terrible situation. And then one other just dot on the Hochberger representation is one of his underlings came to me and my dad shortly before the trial, and he said, Scott's got a message for you. And it's like, what's that message? He says, this is Scott Hochberger, Attorney General Scott Hochberger. He'll pay you if you win, but he's never going to have to pay you because you're never going to win. So this is the tack they took. Crush them, beat them. They didn't care about the injury. They didn't care about the harm. They didn't care about anything. So then the next AG comes in, Thomas Riley. More of the same. He runs this, I can stand idly by and watch my friends brutalize a mentally ill person. I don't have any obligation to stop it. The thing that's really insane about that issue is this. It's real simple. Not only do you want to be excused from doing anything, but he wanted his clients to be justified in pinning Jason Davis to the floor so that somebody else could try to murder him. It was absolutely insane. So Hochberger runs all his issues, but Riley, Thomas Riley stepped in January of 1999. He just got in as AG and was off to the races. But he had the luxury of seeing what happened at trial. And what did he do? There was a long record, there was a jury verdict, all the transcripts, and he knew the grisly events that were talked to about at trial. And the state police officer was on the witness stand for a day. This was a gruesome, gruesome trial. What did he do? Charge forward. And what did he do now? He takes Paul Rennie, twice convicted of armed robbery, and runs him up through an appeal at the First Circuit, then appeals for Paul Rennie to the U.S. Supreme Court. Joyce Wiegers, he didn't represent her at trial, the AG, but now they bring her on as a client. The jury came back $250,000 against her for punitive damage. Punitive damages are awarded when somebody engages in acutely illegal conduct, evil conduct meant to hurt. She doctored up the medical records, false allegation of abuse by by the Hero State police officer. Goes on and on and on.
So the nurse was involved with this as well. That's what you're saying.
The nurse was involved with this as well. She was actually cheering on the beating as it was ongoing. Her boyfriend, as I said before, was Philip Bragg. He tried to murder Jason Davis by snapping his neck in two. She was behind him cheering on the beating. Then it was all done, and Jason was on the floor bleeding profusely. She goes up to Jason Davis and says, "This is what you wanted. This is what you got." Just imagine that. Imagine that.
How did let's go back a little bit. So in terms of the people that got hired at the institution, how did they even get hired with records?
They had a hiring policy, and the hiring policy permitted the hiring of convicted violent felons to be placed in direct patient care capacities if the chief officer at the mental health institution approved it. In this case, Philip Bragg was approved by Alan J. Zampini. He approved it. He was fresh out of jail. Now, as you know, and as you talked about in your first video, the recidivism statistics are through the roof. It was 34.6% of the felons at that time recommitted a violent crime within 3 years. In addition to that, we have the employment records, and we had them as an exhibit at trial. Both Philip Bragg, attempted murderer, and Paul Rennie, armed robber. We had the employment records of them, and it just made your hair stand up straight. The extensive violence, the provoking, the ridiculing, the attitudes that they had with these mentally ill people. And, you know, I'm not saying that convicted violent felons shouldn't be able to get a job, but what I am saying is they should have put them in the wood shop, on the landscaping crew. To put them in a direct patient care capacity is absolutely insane, because those people have to have the extreme amount of patience.
Correct.
They have to be diligent, and they have to be in tune with how to redirect the patient. They also have to be in tune with their psychiatric disorders so that they can know how to combat certain behaviors when they see it. I mean, Jason was easy to distract. And the thing that's interesting about Jason, he had been there several times. I mean, he had these disorders come on when he was a very young child. Never placed in restraints the whole time he was at the Westboro State Hospital. He had 3 different stays there. There was not an ounce of violence in that young man. So then we get to Governor Patrick. He's a real beauty in the context of the Jason Davis case, let me tell you. You know, a lawyer for the NAACP, civil rights lawyer. He argued, I'm told, a case at the U.S. Supreme Court. He was the the chief law enforcement officer for the Civil Rights Division under President Clinton. In his maiden speech, he talks about the protection of the mentally ill, those with mental disorders or intellectual disabilities. He has pretended for his whole career to be an advocate for the mentally ill. You know, if I could just backtrack for 1 second, we have all these people involved, right? We have Maura Healey, civil rights advocate. We have Scott Harshbarger, Thomas Riley, Deval Patrick, Martha Coakley, Karen Spilka. All of these people pretend to the public that they're civil rights advocates. The Davis family asked all of them to help. Not one of them said yes. Not one of them. That's so telling. And 2 or 3 of them act like they came down on a shaft of light from heaven to protect the mentally ill. Karen Spilka holds herself out as a big mental health advocate. Maura Healey does. Deval Patrick does. Martha Coakley does. Martha Coakley had an article in the Boston Herald in 2012 saying, society must help protect the mentally ill. So we get to Deval Patrick. I go in and meet with his underling in 2008. And he says, you know something? There's a state statute that says you can only indemnify negligent conduct. And negligent conduct, as we all know, is conduct that happens by accident or mistake. I don't mean it to happen. If I came into this room and I tripped and I fell into your shoulder and you got a bruise, I engaged in negligence. I didn't want to hurt you, but I hurt you. It was a mistake and you could sue me. Civil rights cases, by their very definition, are not negligence. Somebody wants to intentionally hurt somebody. A police officer intentionally chokes somebody, or something else bad happens, or Philip Bragg intentionally tries to murder Jason Davis by snapping his neck. That's a civil rights case. So Patrick's vantage point on this was, hey, the negligence statute, it doesn't help you here. It only indemnifies negligent claims. But what you can do is you can file a bill in the legislature, because the negligence statute doesn't preclude you from getting payment through another source. So I said, that sounds great. So we file in the spring of 2014. We're getting ready to file a bill in the legislature, just like Governor Patrick had said. And basically he was saying, file a bill. It'll sidestep this negligence indemnification statute. You can get paid that way. So we did the very thing that we did. When we did that, he vetoed the bill as being in violation of the negligence statute. He duped the family, he tricked the family, he engaged in corruption, morally debased conduct. The father, the family was beside themselves, because we thought in Deval Patrick that we had a safe harbor. It turns out that what we had was a wolf in sheep's clothing. So, interestingly enough, though, the veto was overridden. So, no, I'm sorry, he vetoed it, yeah, and then the House came back 159-0.
Yes.
The Senate came back 39-0. They overrode the veto. What did Patrick do then? He wouldn't fund the bill. So the bill died. And by the way, we've been in the Massachusetts legislature 7 times. 7 times. So then we get to Martha Coakley. Now, as I said, Martha Coakley had an article in the Boston Herald in 2012. Society should stand up for the mentally ill. In March of 2014, there was another mental ill case, Joshua Messier case. It was a carbon copy, legally, of Jason Davis's case. Carbon copy. Ill-trained, ill-qualified, ill-supervised mental health care workers killed a committed mentally ill patient during the course of a physical restraint in Messier. In Davis, he didn't die. He almost died or could have died, but he survived. But legally, in terms of the predicates for each case, they were identical. I got a call one morning from my brother Brendan. He says, "You seen the front of the Globe?" I said, "I haven't." He says, you got to go to the store right now and buy it. It's a carbon copy of the Jason Davis case. Go get the newspaper." I went and got the newspaper. Then I talked to a friend of mine in Boston. It was the same case. And I said, "Hey, I got to get to Coakley. I got to get to Coakley on this because we got the same case. They're paying this one. They should have paid it. I'm not saying they shouldn't have paid this. Absolutely should have paid it. It was horrendous." Interestingly, and to backtrack, if they had done what I asked them to do after the Jason Davis case, Joshua Messier would be alive to this day. I offered my pro bono services to Governor Patrick in writing in 2008. He rejected them. I have become a bit of an expert in this pocket of the law. I even proposed a remedy paper. I had protocols, policies, things that would help the state make sure that this stuff does not happen again. Because when Jason was injured, there was a climate of fear at the hospital. People were getting their tires slashed if they reported their windshields broken. Nicholas Tassone, tires slashed and windshield broken because he reported bad things that had happened. So we go to Coakley, March 26, 2014. I send her an email. I say, "Hey," and it was to her right-hand man, a lawyer by the name of Edward Bedrozzi. And I said, "I'd like to meet with Attorney General Coakley. I want to talk about the Davis case." Same case. So they delayed and jerked the thing around back and forth, and, they froze us out. They wouldn't talk to us. They wouldn't give us a meeting with Coakley. In the interim, I heard from a number of people that Martha Coakley was going into the Massachusetts House and Senate and telling people, "Don't pay this Davis bill. I don't want it to get paid." I also heard from a representative, Carolyn Dykema, come into my office in the spring of 2014. She says, "I reached out to Coakley because I was trying to get her help on the bill. Reached out to Coakley, and she says, no way. She's dead set against Jason Davis getting paid." And I said, "Why would she be dead set against Jason getting paid? It's such an honorable thing." So then finally, we're at a position where they're not going to pay us. They're paying the Messier case. $3 million went to Joshua Messier, rightfully so. The family should have been paid. But we were in that bucket too. And we wanted to have the family finally get paid here. So what happened next? We sued Martha Coakley and Deval Patrick. And Maura Healey came in as the lawyer in that case. And what she did, I haven't seen corruption like this in a civil case for the entire time that I was a lawyer. I haven't seen it. Martha Coakley comes in, but she's got a little bit of a problem because she's prosecuting the Messier culprits, the people who killed Joshua Messier. But she's defending Coakley and Patrick. In our case, she wants to show, the Messier culprits just engaged in negligent conduct. It's indemnifiable through the negligent indemnification statute. So Jason Davis is out because his claims are intent-based claims. This was her tact. But yet, in the criminal case, she convened a statewide grand jury. And the statewide grand jury came back with indictments that said that the Messier culprits engaged in willful, wanton, reckless, and intentional conduct. This took it outside negligence and made our case in the civil side because Davis could now say, hey, he was intent-based civil rights claim. They get paid. It's not negligence. I'm intent-based civil rights claim. I deserve to get paid as well. Healey hid these indictments from us. I uncovered them myself, and I attempted to use them on on the appeal in the Davis v. Coakley and Davis v. Deval Patrick case. Interestingly, the First Circuit Court of Appeals would not allow these documents into the record. I have no idea why. We filed the motion. They were supposed to hear the motion. The motion never got heard. It was never discussed in the appellate proceedings. It was never part of the record. But ironically enough, in their reported opinion, they say, well, the plaintiff in this case, Jason Davis, has not shown a judicial termination by some judge or some judicial body that this was intent-based conduct. We actually had a statewide grand jury indictment that showed exactly that. So what they were telling us we had to have, we had, and they wouldn't allow it into the record. So, you know, I thought the part that was really insane in terms of Maura Healey's corruption in regard to the Davis v. Coakley case was this. What do we have for evidence in terms of intent-based conduct? We had a death certificate that said that the manner of death was homicide. We had an autopsy that said the manner of death was homicide. We had an autopsy that depicted brain bleeding. We had an autopsy that depicted blunt force trauma injuries all over the torso. We had an autopsy that showed them leaving a lifeless body on a restraint table for 10 minutes without calling a code red. It goes on and on and on. They murdered Joshua Messier, but yet when it came time to pay and came time to equivocate his case with Jason Davis's case, they ran for two different cases, same exact legal position, different assessment of the issues in each case, depending upon where she found herself. In the Coakley case, she argued negligence. Over here, when she wanted to indict these people, she argued that it was intent-based conduct, willful, wanton, reckless, and intentional. To me, her conduct inside of the Davis v. Coakley case, it's reprehensible conduct, it's criminal conduct, it's corrupt, because the United States Supreme Court has said you cannot argue two different positions on the same legal issue in two different courts at the exact same time. This is precisely what she did. This was a smoking gun of a smoking gun of a smoking gun. These indictments against the Messier culprits. First Circuit would not allow it into the case. Maura Healey did not disclose it. She was fraudulent in not disclosing it. And then we had an abundance, an avalanche of evidence. But, you know, Jason Davis was, and his dad took over. Jason Davis died in 2004. His dad took over for him, but he's a lone wolf. He's a lone wolf up against all these powerful people. So what happened next? Well, what happened next is there was yet another series of cases. The Holyoke Soldiers Home. Holyoke Soldiers Home involved the Holyoke Soldiers Home in Holyoke. 164 people died or were injured as a result of the pandemic. So plaintiffs on the civil side, the Holyoke Soldiers Home case, started a case, a civil rights case, against two of the principal culprits at the Soldiers Home. I just want to go back and say one thing. We won at the Supreme Court. These two other cases that came afterwards are just very narrow cases. They're narrow cases aimed at equality of treatment. What's good for the goose is good for the gander. If you're paying these civil rights cases, we deserve to get paid too. We already won at the Supreme Court in 2002. That's never been set aside. We beat the Attorney General in 3 courts. 1-month trial, First Circuit Court of Appeals, U.S. Supreme Court. These other 2 cases, very, very narrow issues. But interestingly, Maura Healey is involved in these other cases extensively. She knew the record. On the Holyoke Soldiers Home case, 170 victims, 164 victims, started a case against the 2 principal culprits at the Soldiers and Sailors Home. It was a civil rights case, and it was based on intent-based conduct. Maura Healey, though, interestingly enough, on the criminal side, once again, like in the Messier case, she was prosecuting these people. She was prosecuting all of these people. And again, once again, she argued willful, wanton, reckless, and intentional conduct. So their big excuses in these two sister cases were that, well, these people just engage in negligent conduct. Jason Davis case intent-based, so, we get to pay him under the negligence statute. Your intent-based stuff isn't paid under that statute, so you're out. In reality, it wasn't that at all. All of these cases were intent-based conduct. But again, Martha Healey and Andrea J. Campbell, Attorney General, administer this corrupt indemnification program where it's basically a goody grab bag. If you curry favor with the government, or if some case gets into the news that's very explosive and bad for the government, then they make a move. If you don't curry favor with the government and you don't play ball like we didn't play ball at mediation, they get you. You're not getting paid, these other people are going to get paid. When you have a governmental program, like an indemnification program, it must be administered even-handedly, and with the set of rules and regulations that people can know in advance. It's like, all right, how do I get paid and how could I be entitled to such a benefit? It's not willy-nilly and arbitrarily. And that's all they've done here. So we get into this third case. Once again, we have this conduct, and we have the indictments now, which is a judicial determination. A statewide grand jury, again, convened and determined that the Holyoke culprits engaged in willful, wanton, reckless, and intentional conduct. So what happened after that? Maura Healey was the trial lawyer against these culprits. She is the one who's pressing the claim for willful, wanton, reckless, and intentional conduct. So she gets back to the trial court after the statewide grand jury had convened. The judge dismisses her case. She takes it up to the SJC here in the state. What did they say? Willful, wanton, reckless, and intentional conduct. Bingo. Bingo. Gold of gold of gold. Smoking gun of smoking gun. You know what else happens? After that, we had that information in our complaint. That's why we filed a complaint against Maura Healey based upon the Holyoke Soldiers Home case. It's like, hey, that's willful, wanton, reckless, intentional. They got paid. We're entitled to get paid. What happens after that? They actually take a plea agreement in that case, the two culprits. Now, a plea agreement is a judicial finding. And basically, they came in and admitted to sufficient facts, which basically means we admit to all facts which would warrant the prosecutor getting a win at trial. And that's how we dispose of the case. In exchange for that, you go on probation, you do your time, and the probation ends. We had what we thought was the biggest smoking gun in the world. So we file a motion. Now, we were in federal district court. Now, keep in mind now, again, it's Jason Davis's 87-year-old father and me. That's who it is. And we're against the Attorney General of the state, the governor of the state. Lawyers can't cast aspersions on judges. They have to go right up to the line. Like a lawyer cannot say that a judge is crooked or he's underhanded. But what a lawyer can say is a lawyer can recite the facts. What a lawyer can say is that there was no basis in fact or law for a decision. There was no basis in fact or law under the Constitution for a decision. What occurred with Judge Jewin at the federal district court on this case was very surprising to me. And Judge Jewin was appointed by President Biden, so he's a Democrat, and he was appointed by Deval Patrick to his state court seat. He was a judge at the BMC in Boston. Now, Maura Healey, she was on the campaign committee for President Biden in terms of his reelection. Andrea J. Campbell is a Democratic power broker. So we have Democratic power broker Andrea J. Campbell. Democratic power broker, sitting governor of the state, is a defendant in this case. Then we have the judge in this case, appointed by Judge Biden, appointed by President Biden, and appointed by Deval Patrick to his state seat. And who do we have on our side? We have Jason Davis's 87-year-old father and me. It was one of the most surprising cases I've ever been part of in my life. There was a motion to dismiss in that case. We weren't entitled to a hearing. Been a lawyer for 34 years. Every motion to dismiss I've ever had filed against any case I've been a part of, you're entitled to a hearing. I've never seen a motion to dismiss or a summary judgment where you haven't gotten a hearing. But in that case, we got no hearing. In that case, the gold of the gold, which was the plea agreement, which would show that there was a judicial finding of willful, wanton, reckless, and intentional conduct, the judge would not allow the motion. We sought to introduce those documents into court. He would not allow the motion. First time we got to court, the judge says to me, the first words out of his mouth is, and it was there because the Maura Healey didn't file an answer in a timely fashion. I moved for a default, which you're entitled to do after 21 days. If they don't do it, lawyers can move for a default. And lawyers live by the rules. So the first thing the judge says to me on January 10th, 2023 is, I don't even know what I'm doing here. And inside the motion, we had embedded perjury that was undertaken by the Attorney General's office in the context of the motion to remove the default. In addition to that, he chided me on moving for a default too quickly. Then he chided me for accusations of perjury in my papers. I did make accusations of perjury in my papers against the Attorney General's office, but they were fact-based. And there was 7 or 8 pages in my motion that was devoted to that very issue. So what we have here, from a global standpoint, is we have a series of corrupt acts over 32 years. And we can link up all these acts. You go from Scott Harshbarger to Thomas Riley, to Martha Coakley, to Deval Patrick, to Maura Healey as assistant AG, and then as governor, to Andrea J. Campbell. You know, I tell people it's a little bit like having 7 NBA players in your backyard to play basketball. They're there for 4 hours and nobody can hit one shot. Something's got to give. We asked all of these people to help us get justice. All of them. All of them said no. Just that fact all by itself, that none of these people would step up to do the right thing. They all say that they're civil rights leaders. They all say that they're advocates for the mentally ill. Karen Spilker, too, I get a kick out of what she did here. I contacted Karen Spilker. You know, you heard the quote about her supporting the Davis litigation and the Davis bill. She files a bill for the family. We're very excited because she has a lot of power in the Senate. So we're waiting for the bill to happen, and then the bill gets denied. Then I call the clerk for the Senate's office, and I said, what happened on this bill anyway? Could I get the transcript of what was actually said by Karen Spilker? Says you can't. I said, well, how come? There's no way to get the transcripts? He said, no, it's not so much that. It's that when the bill was called, my records indicate that she didn't even stand up to talk about the bill. So when you're the sponsor of a bill, your bill's called, you stand up and say, hey, this is my bill. I got Jimmy Smith, and here's what I'm trying to do here. Won't even stand up. You know what she did? She filed the bill just to placate the Davis family. When the bill was called on the floor of the Senate, she didn't say a word. And I talked to the Senate clerk. I invite anybody in your audience to talk to the Senate clerk. But it was absolutely pathetic. One other thing, one other dot here. And I'm sorry to hog the microphone here.
Listen, this is, this story is...
It's unbelievable.
It's really unbelievable.
It's unbelievable. On April 10, 2023, I meet with the first assistant for Andrea J. Campbell. I sent Andrea J. Campbell a letter, a long letter, and I think I sent it to you, and on about the February time frame, laying out this whole thing. So we get into a meeting on April 10, 2020, Ashburton Place, Attorney General's office. I got the first assistant, Pat Moore. He is the next guy in line, number 2 guy at the AG's office. You couldn't meet with the better guy other than Andrea Campbell, who would not meet with me. I tried really, really hard. So we meet, and I had 2 people from my office associated with my office, and he had an assistant attorney general there as well. So there were 5 people in the room. And I wrote down what he said. After I talked about the corruption that I've touched on here today, the meeting was about an hour or so, and I did about a half hour, 40 minutes on the corruption piece, and went through line, chapter, and verse. And then he says to me this, and I quote, he says, "The Jason Davis case never should have happened. If our office were involved in this case, it never would have been defended like it was, if at all." He then asked, quote, "How should we pay this?" So it seemed to me that I felt like we were on third base at that point in time. He knew it was wrong. He knew it shouldn't be defended like that. He was asking how it should be paid. Mr. Davis spoke eloquently at that session. He was on the phone, and geez, I tell you, when he was done with his speech, I said, geez, I'm hard pressed to beat that. I couldn't beat it. It's his dad. He's his dad, for crying out loud. 87 years old. After that, Pat Moore froze me out. And I asked him before he left, as he was about to get to the door, I said, Mr. Moore, can I call you? He said, call me. Would never take my calls, would never respond to my emails, would never respond to my letters, absolutely nothing. Freeze out, freeze out, freeze out. So, we go from the hallway at Westboro State Hospital to the U.S. Senate building in Washington, D.C. And for my money, they're all in the same bucket. Corruption, corruption, corruption. I don't care what definition you want to use of corruption here. It's wrong. We even had a bill before Congress. We were trying to repair this defect, and we consulted with Joseph P. Kennedy III on a bill that would make it so that states cannot abuse the mentally ill and then run off to the hills after they lose. See, right now, a state, as Massachusetts did here, they took all the fruit, but none of the thorns. All of the roses, but none of the thorns. They litigated in 3 cases over 7 or 8 years. They spent millions of taxpayer dollars to defend the indefensible. And then when they lose, on the very day that they lost at the U.S. Supreme Court, they withdrew from the case because at that time, it was time to pay the fiddler. At that time, Scott Harshbarger's promise to pay came due. And what did they do? They ran for the hills. Interestingly, with Andrea Campbell, I raised the issue. It's like, hey, we got this bill pending in Congress. We'd like your help on the bill, and it would like your help on filing state legislation. And by the way, I drew the federal bill. It's an amendment to the Federal Civil Rights Act. I drew it myself, 116 H.R. 9060. I provide all the briefing to the House Judiciary Committee in advance of the pre-approval of the bill. And I also drew a state bill. So we did it all. We handed it to them on a silver platter. You think that they would have been interested in getting the cure. Because I tell you, Jason Davis was not the first person who got brutalized in a Massachusetts state hospital. I've been consulting in this area and consulted with scores of clients over the last 30 years. And some of the stories I see and pictures I see, they're absolutely unbelievable. Unbelievable. So where do we go from here, I guess, is the question. We've been through the legislature 7 times. They won't pay. We've tried 3 federal cases. They won't pay. And interestingly, too, the First Circuit in the Coakley case and Judge Joan, we had smoking guns twice. The best evidence that we could put in front of each court, we put it there. They won't allow it into the record. They won't allow it into the record. I think the record in front of Judge John is just an incredible record. And I would invite scholars, constitutional scholars throughout the country to look at all these cases. Davis v. Rennie, Davis v. Coakley, Davis v. Healey, all filed in the Federal District Court in Boston. And Coakley, of course, we had the appeal to the First Circuit as well. And, of course, in the first iteration of the Davis case, the one that happened way back, we did all 3 courts. So, for my mind, I think what I'd like to see happen is I would like to see Maura Healey and Andrea J. Campbell indicted by a federal grand jury after they convene to consider what occurred in the context of the Davis case. I think it's clear on the face of the documents that we presented to the courts. And I would say this to the Department of Justice. I do hope that the Department of Justice gets involved here, because the blueprint for an indictment of Maura Healey and Andrea J. Campbell is my 87-page complaint that I filed in federal district court on September 12, 2023. All the other documents on the docket sheet speak to that same issue. This is corruption. You can't have a goody grab bag. You can't administer a goody grab bag. But there was one other case I think I forgot to talk about. And if I did, please remind me. The House of Horrors case, did I talk about that?
No, not that one.
All right, quickly, I know,
Sure.
I'm
No,
a
do
little
your thing.
long-winded here, but one of the other predicates for our claim, most recent claim, the Holyoke case, so to speak, when we use that as a predicate to say, hey, how about us? Theirs was willful, ours was willful. House of Horrors case. House of Horrors case involved placing foster children in foster homes by the Commonwealth of Massachusetts. 4 foster children were placed in a home in Worcester County, in the Worcester County area. And on August 11th, 2023, Maura Healey settled that case for $7 million in conjunction with Andrea J. Campbell. They both teamed up to settle that case. It should have been settled. I totally agree with that. I think the $7 million was a little short, but that's really none of my business. But what is noteworthy to me is that this case involved rape, serial rape, digital rape, sodomy, sexual assault, sexual abuse, sexual harassment, compelling the foster children to drink their own urine, compelling the foster children to eat their own fecal matter, acts of bestiality, whipping the foster children with chains and dog leashes, placing the foster children in dog cages, some of the most horrific conduct you'd ever even think about. Who was the attorney defending all these defendants at the get-go? It was Maura Healey. What did she do? What's the first thing that she did? First thing that she did was file a motion to dismiss in that case. You'd think that her heart would go out to people like that. You'd think that she'd do the right thing from the get-go. You'd think that litigation would have been totally unnecessary. But she fought and fought and fought. Then finally she settled the case. When she settled the case, again, send another email to Andrea J. Campbell. It's like, hey, look, this is the same thing we're talking about. That's intent-based conduct. And by the way, there were rape indictments and indecent assault indictments against the 2 culprits. So there was a judicial finding by a grand jury that people had engaged in, rape is willful conduct. It's not negligent conduct, obviously. But just the vast record there and how the children had suffered, we used that as a predicate too. Didn't get us anywhere. But, Jason Davis is kind of fighting an uphill battle. And 7 times through the legislature, no luck. We tried the court system. None of these alleged civil rights attorneys, civil rights gurus will help us. But when you get 6 or 7 people who say no, and all of them profess to be civil rights advocates, then one thing is clear. There's a conspiracy afoot. And this thing all came back to the mediation. We won't take their cheesy, illegal, immoral, scandalous offer. Then we do a 1-month trial, we beat them, and the First Circuit set forth a variety of errors made by the Attorney General's office in the context of that first Davis case. So they dug in their heels, and Maura Healey, as I said at the outset, was handed the corruption baton in 2014. And boy, did she run hard with it. She asserted those scandalous positions for Coakley. She ascended those scandalous positions for Deval Patrick. Instead of putting down her sword and saying, you know what, this was a bad case. You know what, Deval Patrick did tell you to file a bill. It's time to make this thing right. They can't stand the thought of losing to Jason Davis. It's really incredible, too. Because, Jason Davis did the work of the Attorney General. He made historic laws in the United States that will forever protect the mentally ill. The biggest law that he made, First Circuit Court of Appeals, it binds 5 states, it's persuasive authority in every other state. Doctors, nurses, and mental health care workers cannot stand idly by under the Due Process Clause of the 14th Amendment and allow their fellow employees to brutalize mentally ill in their presence if they have the time, opportunity, and ability to intervene. This case has been cited more than 300 times in reported federal cases, probably tens of thousands of times in unreported cases. The other central pivotal holding in that case was you cannot provoke, incite, and antagonize a mentally ill inpatient under the Due Process Clause, and then use the resultant behavior as the predicate to impose a physical restraint, a mechanical restraint, or a chemical restraint. That's precisely what happened in the Davis case. They incited him, they antagonized him, they provoked him, and then they used the resultant behavior to restrain him. And it really wasn't a restraint as we know at this point. Mm-hmm. It was a savage, brutal attack. So I think what happened here is incredible. I think if the public really knew what happened here, it would blow them away.
I mean, it blew me away, this story. I mean, obviously you sent me a lot of the documents regarding it, and I went through a number of them. There's quite a bit. But what's really surprising here is that this case has been cited, you said, over 300 times. And when they're citing a case, basically they're using that as evidence of or proof of something that happened, right? Like, and they're effectively using that to enhance their position to potentially win another case. But the funny thing about that is we can't even settle the case that happened here that's being cited.
I couldn't say it any better. You know,
it's insane. I mean, it's crazy.
As his dad always says, he's a national legal hero in mental health constitutional circles who cannot even get justice on his home soil. How do you even comprehend that?
That is, you know what the thing is, we were talking about this is, and I've been talking about this a lot, and a lot of, these Mara Healeys and so on and so forth, there's a small group of people here. And they are, now I don't know if she's one of them or she's part of this, but the fact is there's a small group of people that are controlling what's happening in this state.
That's
bills
right.
Don't get passed, like you said. I've seen multiple bills that I've advocated for, and they can't see the light of day. And the fact is there's a small group of people that is basically controlling what happens at a legislative level here. And it's really a shame because it's the same people that you said they want to be advocates for mental health and so on and so forth. But they have what we like to call luxury beliefs, right? So luxury beliefs is like, if you were to apply this to this instance, what happened in this specific case, you could take something like immigration, for example, right? And you could look at something like that, and these people are okay with their luxury beliefs in the sense that they're okay spending money and donating to this and donating to that, but don't let it happen in their backyard. Right?
That's exactly it.
That's exactly it. So they're okay to be an advocate as long as they're removed from the situation. Unfortunately, those same advocates are now involved in the situation, right? And they want nothing to do with it. And that's exactly what that is.
Well, we've seen it a lot here in the last year or so. It's
wild.
It's very threatening. Home equity theft. It's a great example. Tyler v. Hennepin was the case that came down. The U.S. Supreme Court said you can't steal somebody's home equity theft. If they owe $10,000 in taxes and the equity on the house is $800,000, you don't get, the government, the town, you don't get $810,000. Case came down on May 25, 2023. 8 weeks later, I sent a letter to the land court judge and said, hey, you got to fix this thing. You got to fix this thing. I sent it to the AG as well. As if people, they were still issuing these titles, these foreclosure titles, absolute title, entitling them to take all the money. What happened? It wasn't until August of 2024 that they actually got a statute in play. You didn't need a statute in play. All you needed on May 25, 2023 was Andrea Campbell to send a letter to the land court judge saying, don't issue these absolute titles anymore. And I know you've been through it with the audit. The audit's another example. 72% of the people in Massachusetts want to see that audit done. I love how the Senate President, Karen E. Spilka, the Speaker of the House, Mariano, and Healey team up with each other and decide, we're not going to follow that law. We think it's unconstitutional. Well, prove it in a court. Don't just say we think it's unconstitutional and we're not going to follow it. We're about America. It's the rule of law here. They do what they want to do. Unfortunately, it sounds harsh, but what we have in the Commonwealth of Massachusetts, tell you what we have. We have a democratic dictatorship. They do what they want to do, when they want to do it. Look at this bill, right? You couldn't get this thing through the legislature? Chairman Markowitz, summer of 2022. Put the thing on the floor. I think it was July 31st, and they were talking about a budget. Tried to get in touch with them numerous times. Actually spoke in front of the Senate earlier in that year, sometime in the January timeframe. I think I sent you the video. They wouldn't do it. But the fix was on here. The fix was on. All the little dots connect. They're not going to allow Jason Davis to get justice. And if you don't mind, I would really love to read a quote from Jason's dad, if that's okay with you.
That's totally fine. You do your thing.
Because you know what? Out of everything that's been said in this case, I think that Jason Davis's dad says it better than any human being could ever say it. And it's a little bit long, not too long, so if you'll indulge me on
Sure.
This is a letter sent on June 20th, 2014, by Mr. William H. Davis, the proud father of Jason Davis, who's now 87 years old. At the time, I guess, so we take 11 years off of that, so he's 75, I guess, 76 at the time. This is his letter again to Karen Spilker and a bunch of people on a committee that she was on. Quote, I know that money will never bring back my son, nor will it fully compensate our family for the torment visited upon him on August 12, 1993. However, what I do know is that the payment of judgment, my son's federal civil rights case, will finally mark a place in time where the Commonwealth admits that it was both wrong and not above the law. It will also cement the proposition that the historic laws Jason made will be neither in vain nor unappreciated by the very government which subjected him to the torment which he suffered on August 12, 1993 and thereafter. Improvement, after all, only comes through full accountability. I respectfully submit that government should be characterized by integrity and honor, which to date have been absent here. My son was actually a hero. Although plagued by mental illness and suicidal ideations, he endured a 4-week trial and 2 federal appeals en route to making historic constitutional law which now protects all mentally ill throughout our nation. He should be treated like a hero and not the criminals who both attacked him and were then subsequently protected by the Commonwealth's Attorney General in a host of legal proceedings. The governor, who was then Patrick, the governor recently characterized the Messier case as awful, horrible, tragic, and disgusting. He was right. The same can be said about my son's case. It is time that the Commonwealth of Massachusetts became fully accountable for what it did to my son on August 12, 1993. I call for the entire payment of the third amended judgment entered in his case. No father, in my circumstance, could rest until justice was done for his son. I never will. You know, it doesn't get any better than that. It doesn't get any better than that. But, you know, these people, they will not do the right thing. And it's amazing to me how they all pat themselves on the back. My father used to call them cocktail party civil rights leaders. They like to go to the JFK statue on the side lawn of the State House on November 22 every year. And they lay the wreath and they say a few words and they quote the great orators and the Martin Luther Kings of the world. But in those smoky-filled back rooms, the real story is told. The real civil rights leader stands up when it requires him or her to call out the power brokers in their own party when they have done wrong. The rule of law is absolute. As most prosecutors will say, I prosecute my case without fear or favor. No matter who you are, I will litigate a case against you if you have done wrong. And you know, no reasonable person, lawyer or otherwise, could contend that what happened to Jason Davis on August 12, 1993, and what has happened to him since was reasonable or just. There's no way the complete denial of justice here is in the name of justice. It's just not. This is cynical, it's sick, it's tyrannical, it's autocratic. It's autocratic. And here they go. They'll never make it right. And I implore the legal beagles out there to take a look at all 3 of these cases, because when you look at it, you will say one thing. What happened here, with the exception of the first series of 3 cases, the 4-week trial, the Federal Circuit, U.S. Supreme Court, those other 2 cases, travesty of justice. There's not a grain of facts, there's not a grain of law that supports what happened in those two cases. But again, it's 87-year-old Mr. Davis and me fighting the cause, and we're fighting a lot of powerful people, and when you fight powerful people, weird things happen. Weird things happen. So I just hope that the Department of Justice gets involved here, because to allow a governor and an attorney general to run roughshod over the populace, like I get a kick out of Andrea J. Campbell. When the home equity theft thing came out, she kept on saying, well, we agree that it's unconstitutional. But people's houses were still being stolen for like 12 or 14 months after Tyler came out. Any really sharp lawyer got Tyler in on May 25, 2023. That night, he would have said, all right, I got a fix. I'm going to call and send a letter to the land court judge tomorrow. The land court judge is the only one who issues these tax foreclosure titles. I'm going to send him a letter, and I'm going to tell him to refrain from issuing these absolute titles. And the absolute title was basically, we get to take your tax money and we get to take all your profit. So if you owed 10 grand in taxes, the house is worth 800 grand, you got to take the 10 and you got to take the 790,000 that didn't even belong to the town. All Andrea, and I implored her to do this. I said, hey, just stop this guy. All you got to do is write to him. She came back, oh, well, you know, it's a long process and a new statute. You didn't know a new statute. You had a U.S. Supreme Court case on Fifth Amendment grounds. That's a constitutional imperative to act. But, you know, you've seen it, too, in the things that you do, and I'm a fan of that. The audit, the home equity theft, what happened to Jason Davis? These inequities have to stop. And as you just said, too, I couldn't put it any better. What they say out front and what they say behind closed doors, behind the curtain, as you said at the outset.
It is what it is. It's how it happens. Does he want to? Oh, yeah. You want to come on and say something? Okay.
All right, John Franco.
You can introduce.
Yep. John Franco is my stepson. He's a wonderful kid. He's in 10th grade, and he's at Mount St. Charles in Woonsocket, Rhode Island. He's been a big fan of this case as we've gone along here. He's seen the ups and downs. And what do you have to say, John Franco?
Honestly, something I really like to say is how evil this case really is. Like, it's just honestly shocking to see, like, just to hear about this in general, because like I could not imagine the pain that he went through in that moment in 1993 when in that hospital, and I can't believe how Maura Healey is just trying to hide this like it's just nothing, like it's just a little screw up that they made. But no, it's a real like important matter that needs to be discussed, and I think they need respect. I think they deserve the money. I think they deserve to be compensated for all of this, and I think that Maura Healey deserves a good amount of hate for this, because this is very, very, very serious, and I just think it's just appalling in general. Like, that's all I have to say about this. This is like really appalling.
What do you think about people in your age group in terms of justice? I mean, is it your opinion from your friends and people who you see, kids in your age group, are they keen on justice?
Yes, I'd say just like in my entire generation, like Gen Z, Millennial, Gen Alpha, I think since like on social media, on that social media presence, I think really that everyone's big on justice, specifically on Twitter, YouTube, TikTok, Instagram Reels. Like, there's a lot of content creators like Ray William Johnson, Danny Reyes, who talk about like politics, talk about justice, talk about like just real world like events that happen. Like, for example, Trump's tariffs and stuff like that. And I think that this could really go big, especially on Twitter and like in that like scene of the internet.
I totally agree, John Franco, and I appreciate your support on this thing for all these years. You've been a great a source of inspiration, because I do draw upon the younger generations. I think it's important to know what they think, and you know, sometimes it's good to get a sanity check from from the young kids.
Yeah, I also would like to add that some people would like just like protest. Like some people have like, as you know, like they would like if something they hear on the news is wrong, they will try their hardest to like bring it out to like the public and try and like protest online. And like sometimes like people, I know this is not as popular as it used to be like back before 2020, like protesting outside, like protesting like because people like typically like with my generation like to protest online instead of like outside.
Yeah.
And like forming a crowd and stuff like that. So I feel like having it on an online presence also would work better because I mean everyone's online, so like.
What do you think about these politicians who say one thing to the public, like all these politicians in the Davis case saying all these nice things about Jason Davis, but then when they get in the back room, they do something entirely opposite? What do you think of politicians?
Absolutely
like that?
evil. Absolutely evil. 100%. I cannot stand that. Like just backstabbing. What it's essentially lying. Literally just saying something to the public, trying to sugarcoat everything. In reality, it's a really evil scene.
Well, thank you for your comments, John Franco, and again, thanks for all your support.
Yes. Thanks.
Great job, guys. Good job, buddy.